It is important to have a complete understanding of the Arizona child relocation laws if you either want to move with your child or intend to prevent the other parent from moving with your child. In Arizona, relocation of a minor child when there's a written agreement or court order between the two parents is regulated by Arizona Revised Statute Section 25408. In most cases, application of this statute becomes necessary when one parent wishes to relocate with a minor child out of state. In some cases, such as in the case of Thompson versus Thompson, the statute can be cited in relation to relocation within the state of Arizona. Under Arizona Revised Statute Section 25-408, a parent granted joint custody and legal decision-making or parenting time is granted the right to a minimum of 60 days written advance prior notice of a relocation of the minor child by the other parent if that relocation is going to be more than 100 miles within the state of Arizona. On appeal, it becomes necessary to discuss and interpret what is intended by the portion of the statute mandating that it applies to in-state moves more than 100 miles. A disagreement occurred as to how that distance should be measured in the Thompson versus Thompson case. The Arizona Court of Appeals determined that the miles of a previously court-approved and completed relocation of the child may not be considered when determining whether a new relocation within the state is more than 100 miles, and that the 100-mile condition should be measured from the location of the relocating parent's physical location as of the date of the court order designating custody and parenting time for both parents. In the case of Thompson versus Thompson, mother was granted her request to move to Show Low at the same hearing for temporary orders that granted custody of the children to her and visitation was awarded to the father. Mother then moved from Alpine to Show Low as granted by the court. In May of 2005, the court entered a decree awarding legal custody of the children to mother and liberal visitation to the father. Over a year later, mother notified the court of her intention to move from Show Low to Payson, Arizona, in order to start a full-time position. The approximate distance of the move from Show Low to Payson was about 90 miles. The father objected to the move, arguing that the move exceeded the limitations presented by Arizona Revised Statute Section 25408 because Payson is approximately 138 miles from Eager, which was father's place of residence. He petitioned the court to prevent the relocation of the children with their mother. The court denied father's request as the distance of the move from Show Low to Payson is 90 miles, less than the 100-mile limitation per Arizona statute. Father moved for a new trial presenting two arguments: that the distance of mother's currently proposed move from Show Low to Payson should be added to the distance of her previous move from Eager to Show Low, and secondly, that the distance of the move should be calculated from his residence in Eager to the proposed relocation to Payson, not from mother's current location to her proposed new location. The trial court denied the motion, finding that the first move was separate and distinct from the second, and that the starting point to measure the distance of the move would be from Show Low, as that's the location where the children were residing. On appeal, father presents the same arguments. The Arizona Court of Appeals looked to the meaning of the statute through the interpretation of its plain language. As such, it concluded the requirements of the statute are not triggered until a written agreement or court order is in place regarding custody and parenting time between the two parents. Section 25408B does not designate a starting point for measuring the distance of the move when relocating the children. As the statute is silent regarding this issue, the Arizona Court of Appeals considered the intended purpose and spirit of the legislation as well as the effects and consequences. It is understood that the intention of the legislature is, in cases where joint custody and parenting time is granted, that one parent cannot frustrate the parenting time of the other parent by relocating with the children. At the same time, the legislation is intended to give parents granted joint custody and parenting time flexibility regarding where they live. It's an attempt to balance the competing interests that exist in this situation. As such, the Arizona Court of Appeals found that the distance of the move should be measured from Show Low, mother's current residence, and the residence of both mother and the children at the time the decree was entered by the court. The distance from Show Low to Payson is approximately 90 miles, within range of the 100-mile limitation imposed by the statute for relocation of a child in the state of Arizona. The Arizona Court of Appeals affirmed the Superior Court's determination that Section 25-408B is not applicable to this case and allowed mother's move from Show Low to Payson.